You've got the 2-year green card after applying with your U.S. citizen or resident spouse, and now it's time to change it to that permanent 10-year green card. What should you do and expect during this process? I'm U.S. immigration attorney Sharifa Tharpe. I help clients get to successfully remove the conditions on that 2-year green card to get the 10-year green card and navigate this process successfully with or without your spouse. So, if you obtained your green card through marriage that was less than 2 years old, you must file this form I-751 to remove that temporary condition on the card to get the 10-year green card. Now I'm going to walk you through everything: when to file, how to file, what evidence wins, and what to expect going forward in this process. First, why does this condition exist? For a marriage that's under 2 years, the conditional green card is there to ensure that the marriage is genuine. So not just for immigration purposes, so it's sort of like a probationary period. Now, once they determine that it's really a real marriage, not for immigration, they give you the chance to move to the 10-year green card within 90 days before the card expires. Now, if you and your spouse are still together, you're living together, you must file jointly. There's no ifs, ands, or buts. But if you're no longer together, you must file a waiver. And that waiver could be based on divorce, mistreatment, abuse, extreme cruelty, or your extreme hardship. So let's break it down. With a joint filing, if you and your spouse are still married and live together, you file an I-751 together. You both must sign that form, and you list your spouse on the form. You'll submit updated evidence of your life together and your bona fide marriage, like joint taxes, shared lease, mortgage, joint bank accounts or credit cards, shared insurance, your children's birth certificates, photos together, vacations, travel together, affidavits from friends and family. Now, make sure that the evidence covers from the date you got the approved green card, the 2-year green card, up until the date that you file, and continue to gather evidence along the way up until your interview. So you can bring that updated evidence to the interview. Now, if you're filing a waiver because you are not filing jointly with your spouse because maybe the marriage ended before you could file, or while you're filing, if you got separated while you're filing, or you were mistreated or abused, or you don't have the option of joint filing and you're going to face extreme hardship, then you need to file this waiver. And in the case of this waiver, you will not get that 10-year green card without showing evidence that you qualify for this waiver. So you still have to show that you entered the marriage in good faith, that you live together, and now you have to show that despite that, you qualify for a waiver based on the divorce or death, once again, based on mistreatment or extreme cruelty, or based on extreme hardship if you were to be removed. You'll need extra documentation. So in addition to showing bona fide marriage, you're going to need divorce decree, if that's applicable, death certificate, if that's applicable, and then any other kinds of evidence that can show mistreatment if that was the case. Now, you're going to need to show solid, strong evidence because they're really scrutinizing these applications with these waivers. Let's talk about evidence. So, of course, once again, you're going to have to show the marriage was real, except for where you're showing extreme hardship. Now, even if you're now divorced or separated, you still have to show that that marriage was real and it just didn't work out. To do that, still show things like joint bank accounts, even if it's in the past, just after you receive the 2-year green card. Show joint tax filings. Make sure you show any kind of insurance together, any children that were born to the marriage, any joint utilities, any registrations in the both of your names, photos together. Now, be mindful of showing red flag evidence. Here's some kind of red flag evidence. You're showing old evidence from the first green card that you got. You're showing outdated lease agreements, tax returns. You are not showing enough documentation to show that you are building a life together in the most recent 2 years from the date you got the green card up until the date that you filed. Also, if you have other types of evidence of mistreatment, put those in: text messages, correspondence, any kind of reports that you had to make. Now, let's talk about the interview. They are going to schedule an interview, whether you're going to go in by yourself or you're going to go with your spouse. So this is where it's very important to make sure you bring that updated evidence with you. And if you file the I-751 jointly, but you're no longer together, make sure you file that waiver. Sometimes you can raise that waiver at the interview. Now, timing is critical, especially now, because the I-751 must be filed during the 90-day window before your conditional green card expires. Filing too early may lead to a rejection. Filing too late can result in automatic termination of your status and referral to immigration court for deportation. So make sure that you update your addresses with USCIS so you don't miss any interview notices or any decisions or any opportunities to respond to questions they may have. That can become devastating. Now, try to avoid filing any bare bones applications with very little evidence. That's a red flag. Build a strong application. So before filing, make sure that you have these things in line. You have your valid card with your expiration date. Note the date that you must file before your card expires, which is 90 days before the card expires. If you're separated or mistreated, you can file at any time, by the way. So that's one thing to know. You can actually get ahead of the game. If you are mistreated, you're divorced now, and you're not going to file jointly with your spouse, you can even file outside of the 90-day window. Just try not to do it after the 90-day window. Also, make sure you're gathering solid evidence, joint documents, whatever you're filing for. If you're filing for a waiver, make sure you're preparing the evidence associated with the waiver. If the waiver is based on mistreatment, show that mistreatment. It could even be your statement that you're presenting. In those cases, once again, show evidence of your bona fide marriage. The timing of that evidence is going to be crucial. Now, make sure that you are also considering getting legal counsel. We help with this. The reason being, the right attorney can get your case going and avoid delays. This process takes around 2 years, but it can go even up to 4 years if it's delayed due to mistakes or issues in your application process. Now, make sure that you file on time, because right now, if you get a denial or a rejection after the deadline to file, you could be referred to immigration court. If you want our team to review your circumstances to get started on the I-751, feel free to call now. If you found this video helpful, click like, hit the subscribe, ring that notification bell, and share with your friends and family and other people who might need this information. Until next time, take care.